Hi there, I'm Savannah Mexto with Mannor Law Group, welcoming you to another Webinar Wednesday with esteemed estate planning and elder law attorney, Bob Mannor. Today's webinar will discuss a potentially life-changing, but not well-known veterans benefit called aid and attendance. Before I pass the mic to Bob, I'd like to first cover a few housekeeping details. First, note that even though Bob is an attorney, today's webinar will not give specific legal advice. If you have a question about your unique situation during today's presentation, please contact us after the webinar. Also note that if you have a general question during today's presentation, please use the question box. We will save time to review questions during the presentation. If for some reason we don't get to your question, we will contact you after the webinar. Also note that today's presentation will be recorded and the replay will be sent out later this week so that you can share it with your family, friends, or anyone who you think could benefit from hearing this information. Now, why should you listen to what the folks at Mannor Law Group have to say? We are a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. Bob is also a leader among elder law attorneys in Michigan. He is currently chair-elect of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. And Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome Attorney Bob Mannor.
Hi, folks. So this is a really good benefit for folks that qualify, and it's a benefit that is for veterans, but a lot of veterans don't realize that they might be eligible for it because it's not just for veterans that were injured during service or anything like that. It's also not just for veterans. It's also for potentially spouses or widows or widowers of veterans. In other words, a surviving spouse of a veteran. So we're going to go through the terms here and talk about it. But before we do that, let's kind of clarify this from the standpoint of the veterans benefits as a whole, because there are probably 3 different areas that the VA can provide some long-term care benefits, because we're looking at this in the standpoint of a long-term care context. And so the one that we're going to be talking about today is aid and attendance, but let me just quickly go through the other 2. So the other 2 are certainly any veteran that has a service-connected issue. And this is particularly true for Vietnam veterans or some that served in Korea that actually served in Vietnam or in Korea and during the time periods that the Agent Orange was used. And so there are so many diseases that we're seeing in the elderly population that have been that are tied to this Agent Orange, and they can get some really substantial benefits as part of that. I have a whole other presentation on that if you want to go back and look at that on our website. We're not going to be talking about that today. But anybody that has a service connected, and we got to look towards that because it's not always obvious. Like Parkinson's or Parkinsonism now is even considered a service connected disability for anybody that served in an area that was exposed to Agent Orange, even diabetes and things like that. So the other one, which is often overlooked, is if you're eligible for discounted or free medical services, and not every veteran is. A lot of veterans assume that they can get, free or discounted medical services through the VA medical, and it's not everybody is. But if you are eligible for free veterans medical with health services, the VA has more flexibility in offering some home care help. Whereas under Medicare and your insurance, generally that's just going to be short-term skilled care. With the VA, they can actually authorize a home care person that is paid through the VA. So really great opportunities to think about. Not the topic for today. Today, we're going to be talking specifically about this aid and attendance benefit. So I always like to talk about, well, what does it pay for? Well, it doesn't really pay for anything. And that's what I mean by that is it's actually a reimbursement program. They actually call it a pension of all things. Most people call it aid and attendance, but the VA calls it a pension, or sometimes they call it improved pension. And why is it a pension? Well, it was designed after the Civil War, and they were worried because there was a lot of veterans that didn't have any income. And so they said, well, our veterans of a wartime period are going to get a minimal income if they don't have any other source of income. And that's the key. And so then it kind of fell out of favor because once Social Security came in, most elderly folks would have some form of income because they had Social Security. And that was going to kind of offset this veterans improved pension. And then in the 90s, they actually changed it to say, well, for veterans of a wartime period, we're going to look at their income as income minus medical expenses. And that's how this all came about, and why it's considered a pension program is it's actually a reimbursement. It's an income because you're spending all your money on long-term care services, you're spending all your money on medical services, home health aid, assisted living, nursing home, whatever it is, you're spending all your income, so your income for VA purposes is zero. So it can help pay for independent living. There's a couple of special rules with regard to that I'll come back to. You can certainly pay for assisted living, nursing home, in-home care. Sometimes if you do it right, you can even pay a family member. There's two things that you need more information about regarding what the money can be used considered a medical expense. First, if it's independent living, you have to have the doctor's statement specifically identify the independent living as a protected environment. So we really want the doctor's statement to specifically say, hey, they're in this independent living, they need to be there because it's a protected environment. The second thing is that you have to be paying for 2 ADLs, especially if you're in an independent living, you have to be paying in addition to just your rent. Can't just be rent. If you're just paying rent, that's not gonna be counted as a medical expense. But if you're paying rent and you're paying for assistance with 2 activities of daily living, dressing, bathing, toileting, eating, getting around, those types of things, then, showering, then you can, the rent will count as a medical expense also. With regard to paying a family member or any kind of in-home care, I highly, highly, highly recommend that you have a lawyer like us draft what's called a care contract, specifically and most importantly if it's a family member. Because, well, the VA does not require that, Medicaid currently does. Now, I'm hoping that Medicaid rule changes someday, but currently Medicaid requires that if you're going to pay a caregiver at home, we need to have a notarized contract. There's a bunch of rules we have to follow. So just be aware of those couple of things. Oops, there we go. All right. Okay, so basic rules about this program. One of the basic rules is you have to have 90 days of active duty. What's interesting about that is only 1 day has to have been during a wartime period. So this is for wartime vets, and I'm going to get to those dates in just a second here, but there has to have been 90 days of active duty. And that's important because a lot of times, I've actually seen a few cases where somebody just had exactly 90 days of active duty and then they got a medical discharge or something like that, or they had a family, discharge or whatever it is, general discharge. But if you got to that 90-day mark, then you're qualified. It can even be where it was 90 days or 45 days here, and then another situation is 45 days here. An example of that might be if you were in the Army Reserves or if you were in the National Guard and the National Guard got called up for federal active duty. So if it is National Guard or if it is Reserves, you have to have been activated for 90 days and it has to be federal activation. So if it was, back in the 70s and 60s, National Guard usually didn't get activated by the federal government. In fact, People used to say, well, they went into National Guard to avoid having to get drafted. That's, you know, sometimes that was maybe true, sometimes it wasn't, but the idea is that National Guard doesn't count unless it's federally activated. Nowadays, if you're in the National Guard, it's a pretty good chance you're going to get activated by the federal government, and you're going to get active duty for federal duty. I've also had situations, actually this has come up a lot, where somebody served more than 90 days of active duty and they don't think that they served during a wartime period at all. They served maybe between Korea and Vietnam, or, you know, just the dates of service don't comply, you know, don't line up with the dates of service of what they consider active duty or wartime, I'm sorry. And one of the things we look at is, well, if you were you in the reserves? Were you in the National Guard afterwards? And were you ever called up? So there is a lot of folks around here that were in the reserves or National Guard in 1968 or 1969, and they were not active duty at the time, but then they were called up because of riots. So there were riots in 68, 69, and the National Guard reserves were, a lot of them were called up for 10 days. And that counts because you only have to have 1 day during a wartime period. 68, 69 was during the Vietnam era. And so because they were activated for 10 days, even though they otherwise didn't serve during a wartime period, it counts because they served for 10 days in 1968 or whatever. Have to have a discharge other than dishonorable. So any discharge other than dishonorable. If it's dishonorable, we'd have to get that changed before we could apply for this benefit. And sometimes there's ways to change that, and there's attorneys that can help with that. A medical discharge, a general discharge, anything like that. This is generally for folks over age 65. And so in theory, you could get it if you're not 65, but then you'd probably qualify under the disability rules. So if you're over age 65, you don't have to prove disability or anything like that. All right, so here's the dates that we were talking about. We don't really see, I'm not sure that there's any World War I veterans left. Maybe there are some widows, possibly, of World War I that could still qualify, or widowers, in theory. World War II, we have the dates listed there, and you'll notice those are not the dates that line up with the history book. They always have some cleanup afterwards, like some time that they count as part of the wartime period, even after the war was officially over. The Korean conflict, we see from June of 1950 through January 1955. And, oh boy, sorry, I'm having PowerPoint issues here, but I'll get back to that. I'm going the wrong direction, apparently. Okay, so 1955, and then Vietnam has a special rule that if you served during this time period, you qualify. If you served between August of 64 and May of 75. However, there's some additional dates for those people that actually served in Vietnam. So we had our advisors, advisors that carried guns and shotguns, presumably, starting in February of 1961. Technically, we weren't part of the Vietnam conflict at that time because they, for whatever reason. So if you served in Vietnam, or if you're, a client or the person you're looking at, your patient, your resident, were to have served in Vietnam between February 61 and August of 64, they would also qualify, even if they didn't serve after August 5th of 64. Everybody else that did not serve in Vietnam, but they served in Germany, or they were in Korea, or they were wherever else, then they have to have served at least a single day between August 5th, 1964 and May 7th, 1975. This does not relate to that other thing where it's service-connected disability, Agent Orange exposure, anything like that. This is specifically for this aid and attendance benefit. Okay, so what is the VA eligibility measure? Well, we have to have a medical need as determined by your doctor, not by the VA's doctor. So unlike some of the other programs through the VA, where you have to go to a VA doctor, this does not require you to go to a VA doctor. You can use your personal doctor. Your doctor certifies that you have a medical need, that you need the regular aid and attendance of another person. you will have to look at income. Now, income's usually easy to deal with. A lot of times I'll have veterans say, oh, I can't qualify because I make too much income. Well, that's not true. You just don't spend enough because remember, the way that the VA calculates income is income minus spending. So if you're spending $6,000 on a assisted living or memory care or someplace like that a month, and your income's less than $6,000 a month, you may have really good income. You may have $5,000 in income. You'd still qualify for this program. In fact, if you had $6,000 in income and you're spending $6,000, you still qualify for this program. In other words, we're just basically saying that in order to get the maximum benefit, your medical expenses or your long-term care expenses have to be more than what you bring in from your pension and Social Security, okay? And then assets, we're gonna talk about assets here. Before we talk about assets, let's talk about the numbers. So, these are the numbers. If you're a veteran and you have a dependent, usually a spouse, you can qualify for tax-free $2,295 every month. And if you're a single veteran, you can qualify for $1,936 every month, tax-free. Surviving spouse, $1,244. And then we have this unusual category of, well, the veteran's healthy, the veteran's still alive. Surviving spouse number is the veteran has passed away. Veteran's still alive and healthy, doesn't need care, but their spouse needs care. So let's say a veteran's healthy and the spouse has dementia or something like that. Well, then the veteran can qualify for $1,520 as reimbursement of the money that they're spending on their spouse. If it's the veteran that needed the care, they'd get $1,936, or I'm sorry, if the veteran needed the care, they get the $2,295 because the veteran and the spouse. But if it's the spouse that needs the care and the veteran's healthy, it's $1,520. These are all tax-free. I just read an article earlier today that it's expected that these are going to go up by about 6%. So people always love it when seems like they're getting a raise in their Social Security or their veterans benefits, and that's great. It also generally means that inflation, that the value of your dollar is going down, and that's why you're getting a raise, is because the inflation. And so what's going to they're trying to keep up with cost of living. And so I have heard, obviously this isn't official and we won't know until about November 1st, but the article I read said it's very likely that it's going to be in the 6% range of the increase that will occur for next year. All right, so then I promised you we'd talk about assets here, right? So here's what you can keep. These rules changed dramatically as of October 18th of 2018. So almost 3 years ago. And that 3 years is important. We'll talk about that. So almost 3 years ago, they drastically changed these rules. Before this, they were not very clear on how much money you could still have and qualify for this. In fact, they basically said, well, we're going to look at all these factors. There's your age and what your actual health is and what your diagnosis is and what your life expectancy, all of this stuff. And I used to say, well, in theory, what they would tell you is they're going to put all that in a can, stir it up, and then pull out a number. And I know that sounds kind of funny, but I mean, that's the way they described it. The VA described it. We kind of knew generally, if you're married, that somewhere between $60,000 and $80,000. If you were single, somewhere between $30,000 and $40,000. So those were the kind of the rules of thumb, but the VA would never say those numbers. They would just say, well, if you have too much, you can apply and we'll deny you. And so, so this is better in that regard, in that not only did they increase the number substantially, they defined it. So just like the other stuff, this will be adjusted for inflation. You can have a house with up to 2 acres. Well, what if you have a house with 3 acres? Well, the house and 2 acres are going to be exempt. And then the other acre is going to have to be counted into the other assets. So you can have a house and 2 acres that's exempt. You can have cars. You can have multiple cars. Unlike Medicaid, they don't say how many cars. In fact, they even say family cars. So in theory, the thought is, at least the way the VA wrote this rule, you could have cars for your kids. I'm not saying that's a good idea or that I would recommend that, but it seems to be what is implied by the wording of the rule with regard to this. So you can have cars, multiple cars, you can have a house and 2 acres, and you can have $130,773 in other assets. And that would include your bank accounts, your investments, other things. Big change is they do not allow gifting. So prior to October of 18, they didn't have a look back like Medicaid does. So they didn't have a gifting rule. You could gift and then apply for benefits. Now what they said was they were going to grandfather anybody in that had made a gift prior to October 18th, 2018. So they say no, the look back is 3 years, but technically the look back's only 3 years up until October of 18, 2021. And then we'll say it's 3 years. In other words, we still have, it's actually two years and 11 months and how many ever days it is that you're watching this video. But as of October 18th of 2021, it'll be a 3-year look back because anything happened before that was grandfathered in. And so then, so when I say no transfers, no gifting, if you put your kid's name on a house, they're going to penalize you. If you took money out and gave it to your granddaughter, they're going to penalize you. There is not an exemption. In theory, and under Medicaid, there's an exemption if you didn't do it for Medicaid purposes. In other words, you never expected to go to a nursing home. You happened to give a nice gift to your granddaughter who was getting married and gave a few $1,000s. The Medicaid has a rule that says, well, if you can prove that it wasn't for Medicaid purposes, then it doesn't count. VA does not have that rule. They basically, it's a strict liability. You gave it away, you added your kids' names to the deed to the house, you got a problem. You're going to have a penalty. Now, the house deed, hopefully the kid would give the house back and we can fix that and still have it exempt. But so this is a big deal. With regard to the house, though, we do have some planning opportunities because if you think about it, a lot of times somebody needs to qualify for this benefit. They have the house, they might be eligible, but they move into an assisted living or independent living. Now they have an empty house. Would make sense maybe to sell the house, but now if we sell the house, it's going to put them over assets. If you have something like that, send them our way, send them to us, and we can help them with that and help them stay qualified and not be disqualified from the proceeds from the sale of the house. So the other big one is no income annuities after October 18th, 2018. An income annuity is where you take money, $100,000, whatever it is, and you put it into this investment that pays you back a monthly income stream, okay? And they said, if you do that, we're going to penalize you. You took $100,000 and you put it into a monthly income stream that's going to pay you $1,000 a month. They're going to treat that as if it was a $100,000 gift. Doesn't really make a whole lot of sense. They have the rationale behind it. There was a bunch of people selling these annuities that were selling annuities to veterans that didn't need annuities. And it was probably a poor product, a poor financial product for veterans. And I think they were kind of trying to combat that. There was a bunch of people out there selling annuities to veterans, telling them they need to get this annuity in order to get veterans benefits, which was not true, but there was a whole bunch of people doing it. And so the VA, one of the reasons why they changed the rule was because they wanted to stop these people from selling inappropriate investments to veterans and then telling them that's what they needed to do to get these veterans benefits. Why annuities? Okay, I can't say for sure, but I have a suspicion, and that's because they get a big commission on annuities. The salesperson got a big commission on annuities, and they get their entire commission up front. Most financial products, they get an ongoing commission, and so they have a reason to continue to be your financial advisor. With annuities like this, the salesperson would often get a big commission up front and then get nothing after that. So they have no incentive to actually help you out in the future. They sold the thing, they got their money, they abandon you basically, or at least that was the problem or the concern that was had. Okay, so that's the two big things. First of all, they've increased the dollar amount. They've clarified, you can't have 100 acres. Before, it wasn't 100% clear as to how much acreage you could have. So now they said a house and 2 acres. What's weird about that, of course, is you could have a $2 million house on 2 acres and it's exempt. Seems a little odd. That's the rule. That doesn't work for Medicaid purposes. That does work for VA purposes. And then so the two other things is no gifting. There's a 3-year look back, and no, none of these income annuities. All right, couple of myths. A lot of times I've heard these things. I'm a veteran, but I can't get this benefit, this pension, because I didn't get hurt during service. Nope, that's not required. That's a different program. That's what the VA calls compensation. You'll hear people say, I've got 20% from the VA, or I get 100% from the VA. That's compensation, service-connected disability, service-connected illness, Agent Orange, hearing loss, PTSD, whatever it is, they tie that to your service, and that's a different program altogether. I did not serve in combat, not required. A lot of the folks that we get the aid and attendance benefit for never served in combat. And then some of them never left the United States. They served in a non-combat area. They never really had to carry a gun. It doesn't require you to serve in combat for this program. You just have to serve during a wartime period, those dates that we talked about earlier. Income is too high. Nope, can't be. You're just not spending enough, okay? The VA defines income for this program as income minus medical expenses or income minus long-term care expenses. So if your home health aid costs more than your Social Security check, if your assisted living or home health aid plus independent living costs more than your Social Security and pension check, then your income for VA purposes is zero. So I do hear people say all the time, oh, I have too high of income. Sometimes people mix up those words, income and assets. And for this program, for Medicaid, there's a clear distinction between income, meaning what you have coming in every month, your pension and Social Security, and assets, which is a whole different set of rules. And I have too many assets, we just kind of went through those asset issues there. All right, so last thing to think about is, can you protect assets? Is there anything that we can do as lawyers to protect assets? And there are a few things, a lot less things than I could do back before October of 2018, but there's still a number of things. Now, if you have $1 million, unless you buy $1 million house, there's not a heck of a lot I could do, except if we do the planning 3 years in advance. So legal planning can still be done, but I say up to 3 years in advance, because if you only have $300,000 and you're spending $5,000 a month and your income is $2,000, we're going to do the math. We're going to figure out, okay, what things can we do to get you to not have to wait the 3 years to qualify for veterans benefits? And there are options. It gets a little bit more complicated, but that's why you have lawyers, because it gets complicated and we figure out all the math and we figure out whether we can protect assets. And if we protect assets, will we get qualified faster than the 3 years? And the answer is yes, if you're in that example that I just gave you. So if you're under $500,000 of countable assets, meaning the house doesn't count, the cars don't count, things like that, it's probably worth a review. You're up to $1 million in assets. If you want to apply for this program, we can protect assets, wait 3 years, and then apply. But if you're low income or low asset already, if you have less than $130,000 in assets, then this is a program that you just have to look at. Do you have the medical need? Are you spending money on care? And assets aren't going to be a problem. Okay. So let's see if we have any questions. And if we don't have any typed in questions, then Savannah is going to tell us how you can get your questions answered in the future here. So she's going to give you a couple different options for getting questions answered. I think we maybe have a few social workers on the call and really watching this video. We always want to be able to be helpful. If it's something that a social worker has a question about this, please follow up with us. Savannah is going to give you some details about how to do that.
Thanks, Bob. And thanks again, everyone, for joining us today. As Bob mentioned, we do have a couple of easy ways for you to contact our team, whether you're a social worker, as he mentioned, or you just want some help. We're here. So one easy way is if you look in the chat, I have our phone number and a link. Our 1-800 number is 1-800-990-6030. You can call that number and talk to our team. We'll ask you a few questions, get some more information, and then you can ask us questions too. If now's not a good time, but you know you still want to connect with us, also in the chat, there's a link. It will take you to a calendar and allow you to choose a day and a time when a member of our team can call you. And again, we'll just ask you a few questions, get some information, and then you'll have the opportunity to ask us questions as well about our firm, about our practice, and of course your situation. So we are here to help. I will be sending out an email in the next few minutes. You can always just reply to that email to begin the conversation, and I'm more than happy to put you in touch with the right person. If you're watching later and you're not watching live, you can always also email info@mannorlaw.com, and that's just info@MANNORLAW.com. Thanks again, everyone, for joining us today, and we look forward to seeing you next time.